Hi, I'm David Demurjian for 10 on Tactics and brought to you by tacticsandtrials.com. Today we'll be reviewing the case of Waid versus County of Lyon. The case stems from a domestic violence incident in Silver Springs, Nevada. Officers Timothy Wright and Brett Willey responded to a 911 call reporting a domestic dispute involving Robert Anderson and his wife Jennifer. During the call, there was no request made for an ambulance. When the officers arrived, they were met outside by the couple's two minor children. The children told officers that their parents were fighting, their mother needed an ambulance, and there were no weapons in the home except for a BB gun. Based on one of the children's statements, it sounded like his mother had been beaten. Robert Anderson was throwing Jennifer Anderson around. Wright called for medics, and then both officers entered the home. Inside the kitchen, Anderson, who was out of sight, yelled, "Fuck you, punks!" Officer Willey, weapon drawn, advanced toward a hallway and ordered Anderson to get on the ground. Anderson, shirtless with no weapon in his hand, ignored the commands and ran down the hallway toward the officers. Willey fired 3 times. Wright followed with 2 more shots. Anderson collapsed and later died from his wounds. All of this was captured on the officers' body-worn cameras. Anderson's estate and family sued the officers in Lyon County under 42 U.S.C. Paragraph 1983, alleging excessive force under the Fourth Amendment and a substantive due process violation under the 14th Amendment. The district court granted qualified immunity to the officers and the plaintiffs appealed. The Ninth Circuit, in an opinion authored by Judge Ryan Nelson, affirmed. The panel held that although Anderson was unarmed, the situation was not an obvious constitutional violation. The officers responded to an ongoing domestic violence situation, had minimal time to assess the threat, and had to make split-second decisions as Anderson rapidly approached them in a confined space. The court found no precedent that clearly established Anderson's rights were violated in these specific circumstances. As the court stated, such specificity is especially important in the Fourth Amendment context, where the court has recognized that it is sometimes difficult for an officer to determine the relevant legal doctrine, here excessive force, will apply to the factual situation the officer confronts. They distinguished prior cases where suspects were not aggressively approaching officers or where the confrontation had clearly ended. For instance, the court cited A.K.H. versus City of Tustin, 9th Circuit 2016, where deadly force was deemed excessive against a non-threatening unarmed suspect. But in this matter, Anderson closed distance rapidly, creating a plausible threat based on the circumstances of a domestic violence call for service. Most significantly, the court concluded that the facts about this encounter do not show an obvious violation of Mr. Anderson's constitutional rights, even when the facts are viewed in his favor. The court then reviewed each of the cases used by plaintiffs to support their contention that the officers should not have qualified immunity in this force encounter. The court stressed the difficulty in reviewing previous Fourth Amendment cases due to the highly detailed fact analysis that occurs in each force encounter. The cases relied upon by plaintiffs ranged from a Fourth Amendment violation involving a prisoner handcuffed to a post in a prison to a 6th-grade student being handcuffed by a police officer. Overall, the court found that none of these cases had alerted the officers to prohibited Fourth Amendment conduct in their encounter with Robert Anderson. Because none of the cases on which plaintiffs rely are sufficiently analogous, we conclude that they cannot put a reasonable officer on notice that the use of deadly force here would be unconstitutional. Thus, the officers are entitled to qualified immunity. Additionally, the court ruled that the officers' conduct didn't violate the plaintiffs' 14th Amendment rights, substantive due process rights. As the court opined, under the 14th Amendment, the 2 minor children of Mr. Anderson have the right to assert substantive due process claims, recognizing the fundamental liberty interest in the companionship and society of one's child. However, there was no evidence the officers acted with a purpose to harm unrelated to legitimate law enforcement objectives. In this encounter, the purpose to harm standard applied because the officers had to make a snap judgment because of an escalating situation. Judge Berzin dissented in part, arguing the officer's use of force was excessive. She emphasized Anderson was unarmed, outnumbered, not reaching for a weapon, and that at least 2 shots were fired after Anderson had stopped advancing. Moreover, she opined that Mr. Anderson's alleged crime did not justify the officer's use of deadly force, and that domestic disputes do not necessarily justify the use of even intermediate, let alone deadly force. In addition, she believed that under A.K.H. vs. Tustin, the officers had sufficient legal notice that their conduct violated clearly established law and should not receive qualified immunity. This decision underscores the danger of domestic violence calls and the tense, uncertain, and rapidly evolving nature of these calls for service. The court will require alternative methods of de-escalation if there is time to deploy these resources and the safety of all parties is not in question. Thanks for joining me. I'm David Demurjian with 10 on Tactics. For more updates on use of force law and civil rights litigation, visit tacticsandtrials.com.